was a bona fide member of the first respondent, Red Wiper Democratic Movement Kenya, as at the 30th of April 2017, when the impugned gubernatorial nominations were held by the first respondent in Machakos County. It is therefore clear that whether rightly or wrongly, the PPDT had made a determination that the ex parte applicant herein was a bona fide member of Wiper Democratic Movement, the first interested party herein. Both the PPDT and the IBC Dispute Solution Committee are pursuant to Article 169(1) of the Constitution subordinate courts with no jurisdiction to overrule the other. Consequently, the committee had no power to arrive at a decision whose effect would nullify the decision of the PPDT. In other words, it cannot be contended that the ex parte applicant was never validly a member of Wiper. It was contended that since the issue of jurisdiction was not raised before the committee, it cannot be competently raised before this court. Whereas it is the procedure that issues of jurisdiction ought to be raised before the tribunal of first instance, the mere fact that this is not so raised does not clothe the tribunal with jurisdiction if it has none, since want of jurisdiction renders a decision a nullity. And this was the position of the East African Court of Appeal in Ansaland and Sons versus East African Records Limited, where it was held that if the court has no jurisdiction, any judgment which it gives is a nullity, as well as in the case of McFoy versus United Africa Company Limited. Regarding the issue whether jurisdiction can be raised at any stage of the proceedings, the East African Court of Appeal in Sultan Saleh bin Galeb versus Saif bin Sultan affirmed that an objection to the jurisdiction of the court may properly be taken for the first time on appeal. I've also referred to Nyang'ao versus Omosa. It is important to find out the nature of the exact dispute before the committee, since this court, being a judicial review court, cannot turn itself into an appellate court and re-evaluate the evidence presented before the committee and arrive at its decision. This court's duty is simply restricted to examining the decision made by the committee and the basis thereof in order to find out whether it was legal, procedural, reasonable, or tainted with any other recognized impropriety that would render it unsustainable. That the parties herein were attempted to introduce fresh evidence that was not before the committee was readily conceded by the third interested party, who however justified that course on what he termed as the tactics employed by the ex parte applicant. From the decision exhibited by the ex parte applicant herein, it is clear from the committee's decision that the complaint that was before it was that the ex parte applicant was a member of Wiper Democratic Movement and Chama cha Uzalendo. Apart from that, it was the third interested party's case that the ex parte applicant was not a member of Wiper previously and only became a member on 6th of April 2017, and thus was not, as per the requirements of the commission, qualified to participate in the Wiper's nomination, having not been a member of Wiper by 5th of April 2017, which was the last day allowed for party defections, invariably referred to as party hopping. That was the case that was, according to the committee's decision, presented before it. Although serious submissions were made on behalf of the commission as to whether the ex parte applicant was in fact a member of the Wiper subsequent to the 6th of April 2017, the committee, as an impartial arbiter, could only deal with what was presented before it. If it intended to raise other issues, then it ought to have put such a case to the ex parte applicant to deal with. And this was the position of the Court of Appeal in the case of Chalisha FCS versus Odhiambo, where it was held that since there was no counterclaim, however sympathetic the judge may be towards the defendants, no order can be made unless by consent outside the pleadings. The object of pleadings is to secure that both parties shall know what are the points in issue between them, so that each may have full information of the case he has to meet and prepare his evidence to support his own case or to meet that of his opponent. As a rule, relief cannot be founded on pleadings. A relief not founded on pleadings will not be given. Cases must be decided on the issues on record, and if it is desired to raise other issues, they must be placed on record by amendment. A judge is not entitled to decide a case on an issue raised by himself without amending the pleadings and put. This rule of pleadings, in my view, is a rule of fairness as opposed to merely a rule of procedure. In my view, its application enhances the requirements of Article 47 of the Constitution, and this is what Section 4.3 of the Fair Administrative Action Act requires. This was the position adopted in Geothermal Development Company Limited versus the Attorney General. In my view, a process by which an administrative body goes on a frolic of its own and turns proceedings in which it is expected to be an impartial arbiter into one in which it becomes the complainant, the witness, and the judge at the same time cannot be said to meet the standard of fairness, and such proceedings would clearly be biased. It is therefore not surprising that the committee restricted itself to what, in its view, was the issue before it, as opposed to what ought to have been the issue before it. In these proceedings, parties have made lengthy submissions on what ought to have been the issue before the committee. In proceedings of this nature, as opposed to appellate proceedings, the court does not go on a fishing rendezvous by looking at issues which the tribunal whose decision is being challenged ought to have looked for. By parity of reasoning, where, for example, in judicial review proceedings, the court finds that a party who ought to have been heard was not heard. It is not for the court to proceed and determine whether a hearing would have changed the decision. Once it is found that the party was not heard, that's the end of the matter, and that decision must be set aside. Similarly, it is my view that it is not for this court to investigate whether there existed other material on the basis of which an otherwise untenable decision could be sustained. In this case, what I can get from the rather short decision of the committee, it found that the claim before it was hinged on the provisions of Section 14.5 of the Political Parties Act, which I have reproduced. If I understand the committee correctly, its understanding of the claim before it was that as the ex parte applicant was promoting the ideology, interests, and policies of the CCU, she was deemed to still belong to the CCU. In fact, in what it termed as its analysis of the case before it, heavy weather was made of the decision of this court in miscellaneous application 67 of 2017, though incorrectly stated as proceedings in the Nakuru case. As a basis for finding in favor of the third interested party that the ex parte applicant belonged to two political parties. In its so-called analysis, this was the only issue the committee dealt with before it proceeded to arrive at its conclusion, in which it found that the ex parte applicant at the time of her nomination was a member of two political parties. It is therefore clear that in its so-called analysis, the committee did not purport to analyze the coalition agreement between WIPA and the CCU, which according to its learned counsel would have been the basis for finding that the ex parte applicant had not resigned from CCU, and even if she had resigned, that she never became a member of WIPA. This court, in its decision delivered on the 14th of June 2017, herein clarified that the said decision did not confer upon the ex parte applicant herein the membership status of the CCU. Accordingly, to the extent that the committee relied on the said decision as its sole basis for finding that the ex parte applicant belonged to two political parties, it clearly took into account irrelevant material. It was said in Minister from Aboriginal Affairs versus PECO, a decision maker will err by failing to take into account relevant consideration or taking an irrelevant consideration into account. These grounds will only be made out if a decision maker fails to take into account a consideration which the decision maker is bound to take into account in making the decision, or takes into account a consideration which the decision maker is bound to ignore. The considerations that a decision maker is bound to consider or bound to ignore in making the decision are determined by construction of the statute conferring the discretion. Statutes might expressly state the considerations that need to be taken into account or ignored. Otherwise, they must be determined by implication from the subject matter, scope, and the purpose of statute. In Zachariah Wagunza and another office of the Registrar Academic, Kenyatta University, this court expressed itself as follows, and I quote, concerning relevant considerations, where a body takes account of relevant considerations, any decision arrived at becomes unlawful. Unlawful behavior might be constituted by an outright refusal to consider the relevant matter, a misdirection on a point of law, taking into account some wholly irrelevant or extraneous consideration, and wholly omitting to take into account a relevant consideration. The holding in the locus classicus of Associated Provincial Picture Limited versus Wednesbury best summarizes these principles, particularly in words of Lord Green, that if in the statute conferring discretion there is to be found expressly or by implication matters to which the authority exercising the discretion ought to have regard, then in exercising the discretion they must have regard to those matters. Conversely, if the nature of the subject matter and the general interpretation of the Act make it clear that certain matters would not be germane to the matter in question, they must disregard those matters. Unreasonableness, attention given to extraneous circumstances, disregard of public policy, and things like that has all been referred to as being matters which are relevant for consideration. For instance, a person entrusted with the discretion must direct himself properly in law. He must call upon his own attention to the matters which is bound to consider. He must exclude from consideration matters which are irrelevant to the matter that he has to consider. If he does not obey these rules, he may truly be said, and often is said, to be acting unreasonably. Similarly, you may have something so absurd that no sensible person could ever dream that it would lay within the powers of the authority and court. It is therefore clear that the only basis upon which the committee allowed the third interested party's complaint was that the ex parte applicant was promoting ideology, interest, and policies of CCU by virtue of the ex parte applicant's name being in the list that was sent to the register of political parties for gazettement. That ground was clearly irrational. If there were other grounds for allowing the complaint, they do not appear in the decision of the committee, and this court cannot surmise as to those other reasons and the weight and impact the committee would have attached to them had they been considered. That's a jurisdiction that is reserved to an appellate court, since this court does not substitute discretion for that of a tribunal. That parties cannot raise issues other than those which were raised before the IBC committee before this court was appreciated by learned counsel for the respondent, who urged the court to ignore issues of res judicata and jurisdiction, as the same were not issues which were raised before the committee. I have, however, found elsewhere in this judgment that an issue going to jurisdiction can be raised at any stage of the proceedings, even an appeal. Similarly, issues revolving around the coalition agreement and the journey narrated by Mr. Nyamodi cannot be the basis for this court's determination. Mr. Nyamodi appreciated that the most important issue, which was however not dealt with by the IBC committee, was the issue of party hopping. In my view, if, as it is alleged, the issue of party hopping was not dealt with by the committee, then even if it was raised before it, that issue may be presumed to have been dealt with pursuant to Explanation 5 to Section 7 of the Civil Procedure Act, which provides that any relief claimed in a suit which is not expressly granted by the decree shall, for purpose of this section, be deemed to have been refused. To my mind, if there were other issues which are placed before the committee, it was incumbent upon the committee to identify the same and deal with each one of them. By failing to deal with the same when the matter was before it, the commission cannot purport to now justify the decision of the committee in these proceedings based on the grounds upon which its decision was not based. It is therefore not difficult to understand why the committee could not have found that the ex parte applicant did not cease to be a member of the CCU based on the evidence presented before it, unless the committee decided to go behind the same and investigate whether they were genuine or not, which it did not purport to do. The committee could not reasonably find that the ex parte applicant had not resigned from CCU party, and this was based on the provision Section 14 of the Political Parties Act, which I have reproduced. That provision was the subject of the decision of Lenaula J, as it then was, in the case of Liam Omondi versus IBC, where he held that, and I quote, "In my view, this provision is clear and requires no more than a literal interpretation. Section 14.3 in effect demands a member of a political party who intends to resign from political party must and is obliged to give a written notice of his resignation to his political party, and if he is a sitting member of parliament, to give written notice to the clerk of the relevant house, and if he is a member of county assembly, to the clerk of the county assembly. That resignation, according to the provision section 14.2, takes effect upon the same being received by the political party or the clerk of the relevant house. Upon receiving the notice, the political party or the clerk of the relevant house shall then notify the registrar within 3 days of receipt of the resignation. To my mind, therefore, and reading at the provisions of Section 14.3 of the Political Parties Act, while Section 33 of the Elections Act and Article 85 of the Constitution together, Section 14 deal with the resignation of a member of a political party from his party. Section 33 of the Elections Act and Article 85 of the Constitution deals with eligibility of any person as independent candidate in an election. The question that then arises is, when does time start running for purpose of both Article 85 and Section 33 aforesaid? To that question, I recall that Section 14.2 of the Political Parties Act provides that resignation from political party takes effect upon a written notice being served on the political party. But what is the meaning of taking effect? The Black's Law Dictionary 8th edition defines take effect as follows: to become operative or executed, to be enforced, to go into operation. Applying that definition in the context of this petition, it means that the decision to resign from a political party comes into force and becomes operational the minute the political party receives the written notice of resignation. I've also referred to the decision of Mativo J in Karoli Omondi versus the Registrar of Political Parties on the same issue. From the foregoing decision, the ex parte applicant resignation from CCU was effective from 5th of April 2017. As to whether she lawfully joined WIPA was not an issue that was addressed by the committee. In any case, that issue had been dealt with by the PPDT, which found that as at 30th April 2017, the ex parte applicant was bona fide member of WIPA. Similarly, as to whether she could, by virtue of being such a member, be validly nominated by WIPA was not dealt with by the committee, and no decisions made by that committee. Since these are not some of the grounds upon which the present application is based, I am barred from dealing with the same as new issues pursuant to Order 53, Rule 41 of the Civil Procedure Rules. It was contended that the ex parte applicant did not place before this court all the material that was placed before the commission, and that had the same been placed before this court, it would have revealed that there were more issues than the ones which the applicant purported to have been before the committee. Whereas I cannot fault the respondent for responding to these proceedings, as the blame was placed on his doorstep, I have however referred to the provisions of Order 53, Rule 71 of the Civil Procedure Rules. Therefore, the only mandatory requirement is that the applicant lodges the order, warrant, commitment, conviction, inquisition, or record sought to be quashed. In this case, the applicant seeks to quash the decision the respondent made on the 8th of June 2017, which decision has been lodged. In this case, the proceedings which the respondents allege are missing are its own proceedings. With due respect, there is some level of dishonesty in the position taken by the Commission. If it genuinely and honestly felt that apart from the decisions sought to be quashed, there were other material which would have assisted the court in arriving at a just decision, nothing would have barred it from lodging the same. It is noteworthy that the Commission instead decided to lodge, and I dare say so inappropriately, an electronic document allegedly containing the list of members of WIPA party, which was not even part of the record of the proceedings before it, while omitting what was, in its view, crucial material which was placed before it. As a judicial tribunal, the respondent tribunal or committee is expected, pursuant to the national values and principles of governance in Article 10 of the Constitution, to be transparent and accountable in its dealings with candidates and the court. It is therefore improper for it to keep its own record from a court and contend that there was some material that was placed before it that is omitted from the record before the court. In my view, as a judicial organ, the respondent tribunal owes a much higher duty of disclosure than the ex parte applicant when it comes to administration of justice, taking into account its role not only in electoral disputes but in the electoral system as a whole. The third interested party contended that the likely consequences, if the court were to agree with the applicant, would be to reopen the race for all those that were validly rejected on similar grounds, would probably run into hundreds and eventually affect the entire election's timelines and calendar. However, I wish to associate myself with the case of Jacqueline Eresley versus City Council of Nairobi, where it was held, and I quote, "The purpose of the court is to ensure that the decision-making process is done fairly and justly to all parties. That the law must be followed is not a choice, and the court must ensure that it is so followed, and the respondent's statements that the court's role is only supervisory will not be accepted, and neither will the view that the court will usurp the functions of the evaluation court in determining the matter. The court is one of inherent and unlimited jurisdiction, and it is its duty to ensure that the law is followed. If a local authority does not fulfill the requirements of the law, the court will see that it does fulfill them, and it will not listen readily to suggestions of chaos. And even if the chaos should result, still the law must be obeyed. It is imperative that the procedure laid down in relevant statutes should be properly observed. Provisions of statutes in this respect are supposed to provide safeguards for Her Majesty's subjects. Public bodies and ministers must be compelled to observe the law, and it is essential that bureaucracy should be kept in its place." Unquote. In my view, what the court was saying is that the public interest plays no part in my view, what the court was saying is not that public interest plays no part in enforcing the law, but the courts will not shirk from their constitutional mandate of ensuring that the law is followed. It is now tried that contravention of the constitution of the statute cannot be justified on a plea of public interest, as public interest is best served by enforcing the constitution and statute, as was held in Republic vs. County Government of Mombasa ex parte Outdoor Advertising Association of Kenya. I've also relied on the case of Masalu and others versus the Attorney General, that the Constitution has to be given generous rather than a legalistic interpretation aimed at fulfilling the purpose of the guarantee and securing individuals full benefit of the instrument. A judge has to pass between the government and the man whom the government is prosecuting, between the most powerful individual in the community and the poorest and the most unpopular. It is of the last importance that in the exercise of these duties he should observe utmost fairness. The judicial department comes home in its effect to every man's side. It passes on his property, his reputation, his life, his all. It is to the last degree important that he should be rendered perfectly and completely independent, with nothing to influence or control him but God and his conscience. The greatest scourge and angry heaven ever inflicted upon an ungrateful and unsinning people was an ignorant, a corrupt, and a dependent judiciary. Unquote. To the foregoing, I would add a timid and spineless judiciary. In Riverside versus Anderson, Lord Atkin held that in this country, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty, for which on recent authority we are now fighting, that judges are no respecters of persons and stand between the subject and any attempted encroachment on his liberty by the executive, alert to see that any coercive action is justified in law. Unquote. The purpose of judicial review is to check that public bodies do not exceed their jurisdiction and carry out their duties in a manner that is detrimental to the public at large. It is a conscious supervision of public authorities involving a challenge to the legal validity of the decision in question. In this case, however, the issue of floodgates being opened by this decision does not arise, since the only ground upon which the third interested party's complaint was allowed, being the existence of the order in miscellaneous application 67 of 2017, cannot be said to be common in those other proceedings alluded to by the third interested party. In this case, the court has found that the other issues raised before this court are the basis for justification of the committee's decision, were not grounds upon which the committee made its decision. The ground upon which it did so was as a result of consideration of an irrelevant factor, hence the decision was irrational and, as usually put, Wednesbury unreasonable. It may well be that the committee based its decision on issues. It may well be that had the committee based its decision on the issues now raised before me, a different outcome might have been reached, but that is not the matter before me, and I cannot speculate on the same. I therefore do not see how the outcome of this application will affect any other matter as alleged by the third interested party, which matters this court is not privy to. It is, however, my view. I find that the only basis upon which the IEBC Dispute Resolution Committee arrived at the decision of the 8th of June 2017 cannot stand legal scrutiny. It was, with due respect, hopelessly unreasonable. In the premises, this motion succeeds, and consequently, I issue the following order. I issue an order of certiorari removing this court for purpose of being quashed the decision of the Response Tribunal made on 8th June 2017 in Complaint 79 of 2017. That decision is hereby quashed. I give an order of prohibition prohibiting the respondent from implementing the same decision. I also issue an order of mandamus compelling the respondent to include the name of the ex-parte applicant as the Wiper Movement political party nominee for Machakos County gubernatorial elections, which are scheduled for 8th of August 2017. I have agonized whether, in the circumstances of this case, I ought to award costs. As submitted by Mr. Nzamba Kitonga, the respondent herein still has the mandate of presiding over the elections in which the ex-parte applicant intends to be a candidate. On the other hand, the third interested party herein has maintained that he is a member of the vehicle the ex-parte applicant has boarded towards her political destination. In the spirit of promoting reconciliation, it is my view, and I direct, that each party will bear on cost of these proceedings. Those shall be the orders of this court.
Much obliged, but may the record show that I am supporting the vote. Can break.
Most obliged for a judgment, my lord. We would ask for a certified copy of your judgment and for proceedings.
I'd recorded Mr. Nyamodi's presence earlier on. The judgment is ready.
My lord would ask for a certified copy of the same proceedings to enable us to take the next steps.
So I've directed that certified copies of proceedings and judgment will be availed to parties at their own cost. The other matters which are actually listed for today, I think we should start at 1:45 in the court 37. Napelekea fanya correction.
Unajua sasa tulikuwa kotini mara ya 8 na tumeshinda. Sasa tunauliza Mutua anasema nini? Tunauliza Kiala anasema nini?